Okay, are we good to start?
I don't know. All the attendees just disappeared.
Yeah, they did.
Oh, hold on. There's one, two. There, here we go. They're coming. We'll have Ashley edit the beginning of this out.
Excellent.
Wonderful. All right. Thank you all for joining. I so apologize that the wrong link was sent out or was not sent out at all. I do apologize for that. So we're getting started a few minutes late, and I don't want to hold anyone up any longer. So welcome. Thank you for joining us for the first ever Quick Counsel Lunchtime Legal Briefs, part of our business education series. Today, our speaker will be Kristin Mendoza of Abridge Law. She's going to be covering everything you need to know about the Federal Trade Commission's new click to cancel policy. So without further ado, I am going to take a back seat here and let Kristin take over.
Okay, thank you. I did not know that this is the first one, so that's an added level of pressure, but okay, we'll go with it. Let me get the presentation started. Okay, and I'm going to shut off my camera so that I'm not looking at myself while I talk. That's annoying. Okay, welcome everyone. I hope your day is off to a good start. I want to thank the Greater Nashua Chamber of Commerce for inviting me to speak to you about the Federal Trade Commission's new click to cancel rule that is going into full effect on May 14th of this year. My name is Kristin Mendoza, and I am the principal and founder of Abridge Law, a business law firm a business law practice advising clients in New Hampshire and Massachusetts. Before we begin, I need to throw up this disclaimer that this presentation is provided for educational purposes only. It is not intended to serve as legal advice or legal opinion. We make no representation that it is a complete description or procedure that would ensure legal compliance, and it is not intended that you rely on it as such. As annoying as that was to just read to you all, do take a second to just notice how this was just presented to you. It's not often that legal disclaimers have relevance to a topic, the presentation topic, but thematically, there are some things in the way that this has been presented to you that is going to resonate with some of the discussion we're having today. So just take a minute to just kind of look at it stylistically. So let me start off with just a brief summary of what the Federal Trade Commission is and what it does. The FTC is an independent agency of the US government. It was established in 1914 when President Woodrow Wilson signed the Federal Trade Commission Act into law. The agency has two primary missions: protecting consumers and promoting competition. More specifically, the FTC enforces laws against deceptive, unfair, and fraudulent business practices, and this includes investigating and preventing unfair methods of competition affecting interstate commerce. The FTC also challenges business practices that could negatively impact a free and competitive marketplace. Last year, the FTC received nearly 70 complaints per day on negative option and recurring subscription practices. This was an increase from an average of 42 complaints per day in 2021. So complaints involving negative option programs have almost doubled in 3 years as more sellers of goods and services have adopted subscription or recurring revenue models. And these complaints tend to include inadequate disclosures for free offers, enrollment of or billing without consumer consent, and inadequate or overly burdensome cancellation or refund policies. Now you're going to hear me say negative option program a lot throughout this presentation. What does that mean? Broadly speaking, a negative option program is any program offered online, by phone, in person, or in print that allows a seller to interpret a customer's silence or inaction as acceptance of an offer. So some specific examples are something called pre-notification plans. This is where sellers provide periodic notices of um, offerings of goods to consumers and then send and charge for those goods if the consumers take no action to decline the offer. Periodic announcements and shipments can continue indefinitely. And for those of you of a certain age, and I am in that group with you, think of the old Book of the Month Club or the Columbia Music Club, where you would have to opt out of the monthly shipment, or else, the product would be shipped to you and you'd have to pay for it. A more modern approach to this is, some retailers like Stitch Fix, they send you something, you get to decide what you want to keep and within a very short period of time. And if you don't send what you don't want back, they charge you for everything that they sent to you. So that is a type of negative option program. Another type is a continuity plan. This is where consumers agree in advance to receive periodic shipments of goods, which they continue to receive until they cancel the agreement. And you see these features on Amazon and other retail platforms for repurchasing common items that you consume regularly, such as hair products or paper goods, makeup, cleaning products, or even shelf-stable food items. Then there are the automatic renewals, where sellers automatically renew the consumer's subscriptions when they expire, unless the consumer affirmatively cancels the subscription. And this covers most subscription plans as we know them, including streaming services and gym memberships. And finally, there's the free to pay plan. And this is where consumers receive goods or services for free or at a substantially reduced rate for a trial period. And then after the trial period, sellers automatically begin charging the full fee unless the consumers affirmatively cancel or return the goods or services before the trial period ends. And you see these a lot on phone apps and on software products. So when we're talking about negative option programs, we're talking about all of these different ways of offering goods or services to consumers. And when we're talking about consumers, we're talking about both business to business and business to customer transactions. So in response to the growing volume of complaints in this area, the FTC took action through its rulemaking authority to develop what we refer to as the click to cancel rule. The final rule was issued on October 16th of 2024, and there are four main requirements to the rule. The first requirement is that the seller may not misrepresent any material fact made while marketing a negative option program. A material fact is any fact likely to affect a person's choice of or conduct regarding the goods or services offered. And this includes misleading information about the terms, the purpose, or the efficacy of the product or service. The second requirement is that sellers must clearly and conspicuously disclose all material terms of the deal before obtaining the customer's billing information. This includes details like the cost, the frequency of the charges, and how to cancel. And clear and conspicuous means a required disclosure that is easily noticeable, meaning it's hard to miss, that is easily understandable by ordinary consumers. So in other words, no hiding the material terms in the legalese of the terms and conditions box that none of us read when we check out from our online purchases, or other types of fine print that get presented at the time of purchase. And so think back to what I said at the very beginning about that disclaimer that I just threw up at the beginning, in terms of something that was being presented with different colored font and bold print, and just two sentences that were fairly easy for you to understand. That's the type of thing that we're talking about when we're talking about clear and conspicuous disclosure. The third requirement is that a seller must obtain the consumer's express informed consent before charging them. This means consumers must expressly agree to the terms of the negative option program, and consent requires first, obtaining the consumer's unambiguously affirmative consent to the negative option program separately from any other portion of the transaction. This is a new, this is going to be a new experience for a lot of online retailers and consumers, having a separate area for obtaining affirmative consent. Second, we need to avoid any information that interferes with, detracts from, contradicts, or otherwise undermines the ability of consumers to provide their express informed consent to the negative option feature. And third, another new thing that is going to be unfamiliar to online retailers or anyone else using a subscription model is that you have to keep the consumer's consent for at least 3 years. There is an exception to that if you can sufficiently demonstrate that you use a process that ensures no consumer can technologically complete a transaction without consent, then you are not required to maintain separate consent record-keeping records. And the fourth requirement is that a seller make it easy for consumers to cancel their enrollment, make it as easy to cancel their enrollment as it was to sign up. And what does a simple mechanism to cancel mean? That means providing a simple, straightforward cancellation process, such as a cancel subscription button on a website. You cannot require a consumer to interact with a live or virtual representative, such as a chatbot, to cancel a negative option program if the consumer did not need to do so to sign up. And I have experienced this, and I'm sure other people on the presentation have as well, where you signed up online and then the cancellation procedure is buried in some FAQ somewhere, and then you have to fill out a form and give information as to when they can call you so that they can call you and, in order for you to cancel, and that is no longer permitted under this rule. And then for in-person sign-up, sellers must also offer multiple ways for consumers to cancel, such as online, by phone, and also in person. So the click to cancel rule became partially effective on January 14th with respect to those requirements on misrepresentation, meaning that as of right now, nobody should be engaging in any sort of conduct that would be considered misrepresentation under the click to cancel rule. The remainder of the rule's requirements covering consent and cancellation go into effect in about 60 days from now, May 14th. Violators of the click to cancel rule can be subject to substantial civil penalties of up to $50,000 per violation. The FTC can also seek court orders to stop or enjoin practices that violate the rule. However, there is no what we call a private right of action, and what that means is that consumers can't directly sue a company that they believe is in violation of the rule. So this isn't something where you would expect to see a lot of class action lawsuits cropping up, because there isn't an ability for private citizens to pursue violations of the rule directly. Their remedy is to report the behavior to the FTC or to their state attorney general, who can then seek redress on their behalf. So there are a number of challenges pending to stay the enforcement of the click to cancel rule. The general argument against the rule is that it's an attempt to regulate consumer contracts for all companies in all industries and across all sectors of the economy, irrespective of the company's disclosures, and creates this onerous new regulatory obligation. And the plaintiffs largely argue that the rule is arbitrary and therefore should be enjoined. These cases have been consolidated and are being heard currently before the Eighth Circuit Court of Appeals. In January of this year, the Eighth Circuit declined a petition to administratively stay the effective date of the rule. So as of right now, the rule continues to go into effect on May 14th. The court has since set a briefing schedule with responses being due this week for the FTC and April 4th for the petitioners. So it's at least possible that the Eighth Circuit may issue a temporary stay or a more formal ruling prior to May 14th. We just don't know. There are also some executive orders under the new administration that direct review of all federal regulations to assess rules for potential rescission or modification, meaning that the current FTC commissioners, one of whom voted against the rule last year and is now the new FTC chair, may take administrative action to pause the effective date or rescind the rule. And we are seeing that with other federal agencies. Most recently, the U.S. Treasury Department is announced that it's taking a similar approach with the beneficial ownership interest reporting rule right now. They plan to issue a new interim rule within the next, I think, 10 days that will largely eliminate that reporting requirement for most US companies. So we are seeing some action in the current administration to deal with some of these rules that were put into place under the previous administration. So how do you plan for compliance given the uncertainty of pending legislation and the new administration? No one knows for certain. I'll give you the short answer first. No one has any clear idea. Certainly there are some sellers that may elect a wait and see approach to see if the Eighth Circuit issues new rulings before May 14th. And those, sellers might be taking steps internally to prepare for compliance, such as modifying their checkout process, creating that separate disclosure acknowledgement that's required, but not going live with that feature until the effective date draws closer. There's also intentional noncompliance, meaning that even if the Eighth Circuit upholds the rule, there will be further appeals to the US Supreme Court, and some may decide to wait it out until final adjudication. And certainly with the people who have been holding out on filing the beneficial ownership interest reports or taking action when the non-compete rule last year was supposed to go into effect, they're waiting it out actually worked in their favor. So that is a strategy, and I'm not going to comment further on that. Lastly, there is full compliance with the rule as it currently exists is always an option. So and for the most part, I mean, other than some of the new record keeping and technical checkout and disclosure options, it may not be such a bad idea, given that we've all experienced difficult to cancel online subscriptions. Doing something that gets you further in line with something that's commercially reasonable is never a bad idea. So with that, I mean, being respectful of your time, I'm happy to take any questions.
Feel free to just drop your questions in the Q&A if you would like to ask any questions of Kristin before we end the call. No questions. Wow. Well done, Kristin. You covered it all then.
Did I do Did you okay? Everyone feels like they know a little bit more than they did 20 minutes ago?
I certainly do.
All right.
Perfect. Oh, hold on. We have a question that's popped in. Um, Adriana, can you elaborate? All it says is if people send. If people send emails with soliciting, will this be part of the new law or not be?
If people send emails with soliciting, I'm not understanding what is meant there. I mean, certainly if you're offering any type of recurring, if you're marketing any sort of recurring fee program or recurring purchase program prior to somebody hitting the I agree, I purchase, you need to present accurate, fair, make a accurate and fair presentation of the material terms. So maybe there's an email where it says, hey, check out this great new service or something. You might not put all of that detail into the initial solicitation, but when they get to the web page or the purchasing, when they start the purchasing process, all of these disclosures and the presentations and processes that are required under the form do need to be observed. I don't think it has to be the very first thing that you tell them, but certainly is part of their purchasing, as long as part of your funnel through your purchasing process. You need to incorporate this in before they hit the I agree button.
There also is a question that says same with automatic text. So I think exactly as you're saying, right? Like it all just has to be very clear. Reply
Yeah,
with stop.
at some point, even if you're sending a little teaser text or something, at some point, you gotta make sure that you're communicating the full deal um before they buy.
Okay, awesome. Any other questions? Perfect. All right. Well, thank you all for joining us. Kristin, thank you for being our first ever quick counsel. We really appreciate it. And for everyone who joined us, stay tuned. We have another one coming up next month, soon to be announced. So thank you again, Kristin.
All right, welcome. Have a great day, everyone.
Have a great day. Bye-bye.